No, please, my lord. My lord, I may be allowed to mention for item number 6, Lordship. Lordship, on the last occasion, was directed to file an additional affidavit. We could file it only this morning, Lordship. A short date may be given for admission here, Lordship.
For?
Item number 6.
You're for?
I'm for the petitioner, Lordship.
Okay, you need to file counter.
No, Lordship, additional affidavit. We were directed on the last occasion to file.
Additional affidavit probably filed, not yet filed.
We filed it this morning, Lordship.
For this morning only.
Yes, Lordship.
So what do you want?
A short date may be given, Lordship. Maybe on the 17th, Lordship,
Okay.
for admission here, Lordship.
Mr.
To show long, Lordship.
Counsel for the petitioner. So you have already filed additional affidavit.
Yes, Lordship. This morning.
Okay. Submitted. He has filed the additional affidavit this morning. Which is not with the records, which has not yet been placed with the record. Stop. And praise for listing this matter after.
Lordship, on the 17th, Lordship.
Matter on 17th.
Lordship. I'll serve copies to the
Hmm.
respondent during the course of the day, Lordship.
Okay. After file, this morning only, and you serve the copy to the Line Counsel for the respondent during the course of the days, staff. The Line Counsel for the petitioner also praised for listing this matter on
17th.
17. Staff. The prayer has not been objected to by the Miss.
Menashino on behalf of L. Iralo for respondent number 2.
Okay, for respondent number 2 and Mr. Jimomi, Line Counsel appearing on behalf of the state and Miss Swenson. Okay.
Lordship, the interim passed
According-
earlier.
according
to
the-
continue.
According to this matter on 17th. Okay, stop. The interim or the pass earlier shall continue till the next date. Okay.
Obliged, Lordship.
Ma'am, please, Lordship.
Yes.
Lordship, I beg to mention hearing item 41, Lordship. Lordship, if this matter may be listed after a week. Item 41 hearing,
List after
1 week, Lordship.
your for.
For respondent number 1, Lordship.
Okay. No objection.
No objection.
Miss
To Yakrulu for the appellant.
Tuekrolo, Line Counsel for the appellant is present. Stop. Mr.
Lucknow, Lordship.
Luckney Pong, Line Counsel for the respondent number 1. Praise for listing this matter after a week. Stop. Is prayed, list this matter after a week. Okay.
Obliged, Lordship.
Lordship, I'd like to mention item number 10. Lordship, I have yet to file an affidavit in reply. Kindly,
Not yet filed. Yes. Who is for the petitioner? Okay. Mr. Praise for how much time you
4 weeks.
praise for 4 weeks time to file affidavit in reply.
Lordship, I am for respondent number 5, Lordship. We have filed our affidavit.
Okay. Mr. Lockney form for the respondent number 5 is also present. As prayed, list is no one appears on. No. Have you informed the counsel for the petitioner that
Lordship, they are the petitioners.
oh, you are for the petitioner? Sorry. Lockney form is also present. As prayed, list is matter after 4.
Obliged, Lord.
Maybe your Lordship. I beg to mention item number 29.
Yes.
I'm for respondent number 2.
Item
29. 2 weeks may be granted.
for
Respondent number 2.
not yet filed. And then wakalat. Have you filed wakalat nama?
Yes, Lordship.
Okay.
Your Lordship, I'm for respondent number 3. I'd like to seek 3 weeks time to file.
You also? Okay,
No,
Mr. Pasek for the Lana Council for the petitioner is present. Mr.
Takala.
You are for respondent number 2 and Mr.
TPH Jamir, sir.
For respondent
I'm
number
for 3.
3. Praise for how much time? 3 weeks. 3 weeks time to file counter affidavit. Affidavit in opposition, no, stop. Is the prayer made by the land council for the respondent has not been objected to by the petitioner staff. Accordingly, list is matter after 3 weeks.
Lordship.
Okay.
Maybe Lordship. Lordship,
Yeah.
I beg to mention item number 3.
Yes,
Lordship, I filed my affidavit in reply today. Lordship. Pleadings are completed. That's number 3. I'm for the petitioner.
so for the respondent,
For the
receive the
respondent.
copy.
Yes, we have received a copy this morning. So kindly give us a week time, Your Honor.
Okay. Mr. Posekapote, land council for the petitioner submitted, he has filed affidavit in reply today itself. Miss
Miss Kim Piana,
land council for the respondent number.
respondent,
All respondent Lordship.
only, yes, yes.
Okay, respondent received the reply filed by the land council for affidavit in reply filed by the land council for the petitioner and prays for some time to go through the same stuff. Is prayed or by the parties, list is matter after
A week,
week.
Lordship.
a week. Okay.
Lordship is an interim. Kindly to
Stop.
continue, Lordship.
The interim order passed earlier shall continue till the next date. Okay.
Lordship.
May,
Lordship, in item 14, Lordship. I'm for number 2. I've received the reply filed by the petitioner. Lordship, if the matter came up after 2 weeks, Lordship, for admission hearing.
Okay. Mr. Pasego Potilan, counsel for the, you are for respondent.
Respondent 2. Respondent 2.
Respondent number 2. Who is for the petition?
I am for the petition.
Okay.
Let it be fixed matter. This is RTA matter.
Okay, Mr. Long Chelan, counsel for the petitioner is present. Mr. Posega for the land counsel for the respondent number
2. Number
submitted.
2.
He has received the
Reply.
reply, affidavit in reply. And prays for some time to go through the same stuff. The prayer is allowed. List is matter after 2 weeks.
As fixed.
As fixed when then? Huh? 16.
16, Lordship.
As prayed for by the land council for the party. List is matter on 16 for admission hearing. Okay.
Reply supplies.
may it please your lordship, I beg
Yes.
to mention item number 2. We're yet to file affidavit in reply.
Yes,
Kindly give us 2 weeks time, your lordship.
reply not yet filed.
Yes.
So, Miss
Kim Piana,
Kimpina, land counsel for the petitioner, prays for father, how much time?
2 weeks
2
time.
weeks time to file affidavit in reply. So the prayer is allowed. List is matter after 2 weeks. Okay.
Your lordship, I beg to mention item number 4.
Or also rejoinder not filed.
Yes, yes, your lordship, please kindly give us 3 weeks time.
Similar order, huh? Okay.
Your lordship, I also beg to mention item number 12.
Well, also reply not yet filed.
Yes, your lordship, can you give us 2 weeks time in this case?
Okay, prayer allowed, huh?
Yes.
Similar order.
Also, your lordship, item number 13,
13 is you with 12 only.
12 and 13, yes, yes.
Yes, it
Yes.
is with 12.
Yes. Much obliged.
Yes,
Yeah, this lordship.
yes.
Lordship, I beg to mention item number 20, lordship. 20.
Counter not filed.
Yes, lordship, on behalf of Pijano lordship,
You're for?
for the state respondents lordship.
You're praying for?
3
How
weeks
much?
time, 3 weeks time lordship.
20. Okay, Mr.
Looking for motion
Mm, so-
for the petitioner.
Lucknow. Learned counsel for the petitioner is present. Miss,
Yes, Chairman.
appearing on behalf of the state respondent, prays for and is allowed 3 weeks further time to file affidavit, the counter affidavit, staff. Is prayed, comma, list is, list is made after 3 weeks. Okay,
Obliged, Lordship.
Bless you.
May I please, Your Lordship? Your Lordship, I beg to mention item number 8. Here, pleadings are completed, so I pray that Your Lordship may list for hearing.
yes, it's ready for hearing.
Yes.
Okay, both the learned counsel for the petitioner, Miss,
Ace Jillian.
and Miss
Kate Secret for respondent 7.
for respondent,
7.
number 7, and also state.
Yes, Your Lordship.
Okay, Mr. Jimomi is first, Land counsel for the state respondents are present, so. The land counsel for the party submits that the pleadings are completed and the matter is ready for hearing, stop. List is matter for hearing after
3 weeks,
3
Your
weeks,
Lordship.
okay,
Instantly.
My pleasure, Lordship.
yeah,
I beg to mention item number 5. Here, the pleadings are completed.
this is also ready for hearing.
Yes, for admission, it may be kindly listed for admission hearing.
Hmm?
For admission hearing.
Admission hearing. Okay, Miss
Kate Secret.
land counsel for the petitioner. Miss land counsel for the petitioner, and Miss appearing on for the land, so land counsel, Miss so and so appear on behalf of the state respondent, staff. The counsel for the party submits that, okay. You want this matter to be released for admission hearing.
Yes, Lordship.
Pleadings, I think it's completed,
Yes.
ready for hearing only.
Yes,
full
it
fix for
was,
hearing?
we have filed just 2 days back.
Okay. Is prayed for by the land counsel for the petitioner, list is matter after
3 weeks.
3 weeks for admission hearing. Okay.
Obliged.
Well, back to mention item number 42, 43, and 44, Lord.
Oh.
This hearing, Lord,
Ah.
42, 43, and 44, Lord. These 3 are analogous matters, Lordship. If this matter may be kindly pass over for the day, Lordship. I've taken the consent from the opposite party, Lord.
Okay. Mr. You are for the petitioner?
I am for the petitioner, Lord.
Okay, Muazzam, land counsel for the petitioner, with the consent of the land counsel for the other side, prays for listing this matter after
Tomorrow, Lordship. Pass
tomorrow.
over for the day, Lordship.
Tomorrow, will it be possible? Friday? Next week?
Lordship, in that
Okay.
case, Tuesday, if this honorable court is convenient,
Tuesday, okay. List is matter
7, Lordship.
on 7th,
Obliged, Lord.
list it accordingly,
Lordship, I also
Please
back to
spread,
mention
list it accordingly, okay.
item 16, Lordship. I may have to file reply if I may be given 2 weeks' time, Lordship. 16.
Yes, reply not yet filed.
Yes, Lordship.
And counsel for the petitioner, Mr. Muazzam, prays for how much time?
2 weeks, Lordship.
Further 2 weeks' time to file affidavit in reply. Miss Mary Lannen, counsel for the state respondent is present. As prayed, list is matter after 2 weeks. Okay.
Much obliged, Lordship.
Your Lordship, I'd like to mention item number 17.
Counter not filed.
Yes,
You are for?
for the state restraints.
Okay,
Pray for 3 weeks' time, Your Lordship.
I'm for the petition.
okay, Mr. 17, you are
Limatish.
Limatosi, non-counsel for the petitioner is present. Stop. Mr. His name, appearing on behalf of the state respondent, prays for how much time?
3 weeks, Your
Further
Lordship.
3 weeks times to file counter affidavit. Stop. The prayer is allowed. List is matter after 3 weeks. Okay.
Your Lordship, I have similar prayer for item 22 and 27.
22 also counter not yet filed.
Yes, Your Lordship.
27 also not filed.
Yes,
Not yet
Your
filed. Okay. So here,
I've taken the I've informed the other side.
Okay, you're for the petitioner
Yeah,
in
I'm-
22.
Yes.
Okay, Mr.
Nansanga here.
Land counsel for the petitioner is present. And then same prayer, Mr. Swenson. Appearing on behalf of the state respondent, prays for how much time?
Three-
3
3
weeks
weeks,
time to file counter affidavit. The prayer is allowed. List is matter after 3 weeks. Okay. In 27 also.
Yes, your lordship.
Okay, Mr. Land counsel for the state respondent. Prays for 3 weeks time, on the, with the consent of the land counsel for the petitioner. Prays for listing this matter, sorry, prays for further 3 weeks
3
time
weeks.
to file counter affidavit.
Yes, sir.
The prayer is allowed. List this matter after 3 weeks. Okay,
And lordship, I'd like to mention item 40 from the hearing list. On behalf of V. Socrates, additional aging. If this matter will be listed next week, as she's engaged in the principal seat, your lordship.
okay.
My lord, may I, as per the last occasion, today, this honorable court is supposed to pass necessary order. Since this matter was heard for 2 times, on 2 occasions.
Next week will be okay. Mr.
This was my lord.
Land counsel for the petitioner is present. Revision petitioner is present, staff. Mr. Land counsel for the state respondent, prays for listing this matter
Next week, your
next week, after a week, List this matter
after 1
after
week.
a week. The prayer is allowed. List this matter after a week. Okay.
Obliged, my lord.
Yes.
Your Lordship, I beg to mention item number 18. His state is yet to file affidavit, so kindly grant me 3 weeks time.
Yes, counter not yet filed. Mr.
Mr. Kachishi lordship, on
Land
behalf of
counsel for
council
the
for the
petitioner
petitioner.
is present. Stop, Miss. The Learned counsel appearing on behalf of the state respondent prays for how much time?
Weeks, Your Lordship.
3 weeks times to file counter affidavit. The prayer is allowed. List is matter after 3 weeks.
Your Lordship, similar prayer for item number 26. Here also state is yet to file affidavit. So kindly grant me 3 weeks.
26 also. Yes, okay. So
And Your Lordship, item number,
Lordship,
26.
I am for the petitioner.
Okay, so not yet filed. Okay, Mr. Saint Young, Learned counsel for the petitioner is present. And Miss Learned counsel appearing on behalf of the state respondent, prays for 3 weeks time to file counter affidavit. The prayer is allowed. List is matter after 3 weeks. Okay.
Your Lordship, item number 11, on behalf of Livika. Kindly let the matter,
11 also counter not yet filed.
Your Lordship, kindly let the matter come up after 2 weeks.
Lordship, if I may be allowed to make a short.
Yes,
submission.
please.
Lordship, this is the second round of litigation, Lordship. In the earlier petition, this court has directed the state respondent to regularize the service of the petitioner, Lordship.
But they have not yet filed counter
Yes, Your Lordship.
affidavit.
Yes,
You file next time.
Yes, Your Lordship.
last chance may be given, Lordship.
Earlier also given.
No, Lordship.
Okay. Mr. Tom Fong Faulkner, Learned counsel for the petitioner is present. And Miss appearing on behalf of the state respondent, prays for 3 weeks time to file counter affidavit. So the prayer is allowed. List is matter after 3 weeks. Okay.
Much obliged, Your Lordship.
Lordship.
Yes.
Please allow me to mention item number 9.
9 also. 9 is
Nine.
ready for hearing.
9, on the last date, I have paid before this honorable court to list it for hearing, but now it is listed under the column of admission.
Okay.
I
So-
think the main counsel is,
We'll list it for hearing.
is for hearing.
Okay, Mr. Learned counsel for the petitioner is present. And submits that the matters, the pleadings are completed and the matter is ready for hearing. However, mistakenly, this matter has been listed for admission. So,
So, my lord, it may be currently 27 May for hearing.
okay. As prayed, this is matter on 27 May for hearing. Okay.
And my lord, item 15, on behalf of P. Suren,
State noted file affidavit.
No, Lordship.
Mm.
My
We
lord,
are yet to receive instruction.
my lord, I've received instruction to withdraw the petition. Since the
Okay.
line is not cooperating.
He's happy.
I'm happy. Lordship.
Land counsel for the petitioner. Submitted, he has an instruction to withdraw this writ petition. Mr. Jimomi, land counsel, appearing on behalf of the state respondent.
Respondent 1 to 4.
Okay, respondent number 1.
There is a private.
Okay, is prayed, comma, this writ petition is dismissed on being withdrawn. No, okay, withdrawn, okay. Yes, disposed. Okay,
Lordship, I beg to mention item number 21, Lordship. Lordship, here I'm yet to receive instruction, Lordship.
no,
So-
scan copy was called for here in this case.
Lordship, by a letter dated, I have intimated the competent authority to produce the scan copy, Lordship.
Okay.
However, till such time, Lordship, I am yet to receive the scan copy, Lordship. So if Lordship may please to grant another 2 weeks time, Lordship. So
Weeks
that
time.
in the meantime, Lordship, I will
Okay.
produce the scan copy.
Lordship, I'm appearing on behalf of my senior Philip Loring.
Okay, Miss So-and-so, appearing on behalf of his in-law, land counsel for the petitioner, stop, huh? Mr. Jimomi, land counsel, land PP. Press, submitted, he is yet to receive instruction.
Lordship.
Scan copy also not received.
Lordship, by letter dated 10th April
Mm,
of this, of last month, Lordship,
mm,
I have intimated to the competent authority, Lordship.
Okay.
However, till such time, Lordship, I am
okay,
yet to
submit that
receive.
he, although he has intimated to the competent authorities, but yet to receive
Lordship,
instruction, stop, and prays for listing this matter after 2 weeks.
2 weeks. Lordship.
The prayer is allowed, list this matter after 2 weeks. Okay,
Lordship, there's an interim.
there is interim.
Yeah.
The interim order passed earlier shall continue till the next date. Okay,
Lordship, I beg to mention item 24, Lordship. Item
24.
Item 24, Lord.
No, no, so here, whether the bail disposed,
Lordship, I am told that, Lordship,
bail allowed or
allowed, Lordship, allowed.
then it has become infructuous.
Yes, infructuous, but since I'm yet to receive that, the order,
the-
Lordship. So,
Since it has
And we-
already been infructuous.
Yes, Lordship. My prayer in the main petition is considered, Lordship, by the
Yes.
IA and
I
Lordship.
think we need to
Hearing-
dispose of,
Lordship, Lordship,
will dispose of, okay.
Lordship,
Just disposal pass only, infrastructure.
Yes,
Okay.
Lordship,
Then should we pass straight away?
Lordship.
Lordship.
Okay, the,
Or else, Lordship, if this matter can come up next week so that I can produce the
no, the only
Okay.
prayer was to stay.
Lordship,
And then the main petition, the bail application has been disposed of,
disposal.
granted, it's not required. Okay. Mr. Muazzam, land counsel for the appellant. Submits that this matter has become infructuous. As the main bail application has been allowed by the land CJM or
Sessions Judge
the land district and sessions judge,
Kohima, Lord.
Kohima. Okay. Stop, Mr. Zimomi land counsel, land PP is also present. Since the matter has become infructuous. Sorry, this matter, this IA stand disposed of on being infructuous. Stop. Okay, this criminal petition is also same?
Yes, Lordship.
Similar order, huh? Infracture, okay.
Obliged, Lordship.
Yes,
I also beg to mention item number 30, Lordship. 30, 31, Lordship, 30, Lordship. It's in the order, Lord.
notice still awaited to respondent number 9.
Yes, your lordship.
Notice upon the respondent number 9, still awaited.
Yes, your lordship.
Okay, Miss
Wickets or no?
land counsel for the petitioner is present.
Lordship, I am appearing for respondents 1, 2, and 3.
Okay, hard Miss so-and-so, land counsel for the petitioner. Mr. Saint Younger, land counsel for respondent number
1, 2, and 3. I have already filed my counter affidavit.
1, 2, and 3. You have filed,
Yes, Lordship.
okay, 2 and 3. And Mr. Zimomi, land counsel for the state respondent, stop, huh? The office note reflect that the notice upon the respondent number 9 is still awaited. So you want to take fresh steps or what?
Yes, Your Lordship, Dusty service.
Okay. The petitioner prays for allowing her to take a fresh step upon the respondent number 9 by a dusty service. The prayer is allowed. Step be taken within of a week from today.
Your Lordship.
Start. List is from today and file affidavit to that effect. Start. List this matter after 3 weeks.
3 weeks, Your Lordship.
Okay.
Lordship, I also beg to mention item 35.
35. So, 35 for when do you want?
Lordship, the state is yet to file.
Same parties.
Yes, Lordship, I am appearing for respondents 1, 2, and 3 here as well.
Okay, here also. So here, what do you want?
The service upon the respondent. Still
Yes,
Respondent
respondent 9.
9. Similar order then?
Yes, Your Lordship.
Okay, similar order. Okay, take steps
Yes, Your Lordship.
within a week, huh? Okay, similar order, huh?
Your Lordship.
Deeply obliged.
Lordship, I beg to mention item 31, Lordship.
31.
31.
Okay.
Lordship, here, service upon respondent number 10 is not completed. So
Okay,
I may be allowed to serve Dusty in this
okay. Miss
case.
K. Chukru, Line Counsel for the petitioner. Had Mr. K. Chukru, Line Counsel for the petitioner, and Mr. Jimomi, Line Counsel appearing on behalf of the state respondent. Start. The step upon the respondent number, the
10.
office note reflect that the step upon the respondent number 10 is still awaited. Ms. Chukru, Line Counsel for the petitioner, prays for allowing her to take fresh steps upon the respondent number 10 by a Dusty
Dusty.
service. So the prayer is allowed. The step be taken within a week from today and file affidavit to that effect. Stop. List this matter after 3 weeks.
Lordship.
So this is along with 32
Yes,
also.
Lordship.
Okay.
Here also, service upon respondent number 9 here.
So
mean,
here
yeah.
is item number
Item 32.
32, 9, nah?
Yes.
So only the respondent number 10 will change into 9. All are same. Similar order. Okay.
Lordship.
Hmm.
May I please, Your Lordship?
Yes,
Lordship, on behalf of my senior IM Tulongcha, I beg to mention item number 19.
19.
Yes, Lordship. Lordship, we are yet to file our affidavit in reply, so can you
Yes, counter not yet filed.
allow us 1 week's time?
Hmm. You are for?
We are for the petitioner on behalf of IM Tulongcha, my senior Lordship.
So who is appearing on behalf of the respondent?
So,
No one. CGSC is also there. Item 19, state not yet filed counter. Who appeared earlier?
Lordship, ZN Mili.
Hmm?
ZN Mili, CGS.
There may not be a party here, Lordship.
Is it?
This,
Counter not, CGSC,
yes, Lordship.
okay. So when do you want?
1 week's time, Lordship.
Okay. Line counsel for the petitioner. Miss,
Come on, Lalong, come on.
prays for listing this matter after a week. The prayer is allowed, list this matter after a week, okay.
Lordship.
Hmm. Yes,
May it please your lordship.
Yes.
Lordship, I would like to mention item 28.
item,
28, 28.
counter not yet filed.
No, counter has not been filed.
Hmm.
I'm seeking 2 weeks time to file the counter now. There is same analogous matters are there. This is WBC 40, 2024.
Hmm.
So along with this,
Lordship, I
the
have,
WBC 41 and 42 must come.
Has it been listed today? No,
no, Lordship,
Okay.
Lordship,
Yes.
Lordship, I have objections to that, Lordship.
okay,
Because if we would have wanted to club the 3 petitions together, we would have filed by 1 single writ petition, Lordship. They are different work orders, Lordship.
okay.
though it was executed by the same contractor and issued by the same department, there are different work orders, Lordship, and different circumstances may exist, Lordship. For
Can be listed together in a day, but cannot be clubbed together.
yes, Lordship.
Okay, so separate order will be passed.
Yes,
But
Lordship.
although, of course, it will be listed together. Okay. Mr. Santiago, non-counsel for the petitioner is present. Stop. Mr. Moan Chen, land senior government advocate. Praise for how much time?
Lordship, 2 weeks time.
2 weeks. Time, for the 2 weeks time to file counter affidavit. The prayer is allowed. List is matter after 2 weeks. Stop, huh? Okay. The
Typical rights.
counsel for the petitioner, respondent submits that along with the, the writ petition number 41.
Lordship, it's all right.
Okay, no need to pass order.
Yes, Lordship.
Okay,
Deeply obliged.
okay.
From the supplementary cost list for motion item number 45.
May I please, Lordship?
Yes,
My lord, this petition is filed under section 482 of the CRPC, bring for quashing of the FIR on the ground that the charge sheet has yet been, is yet to be filed even after a lapse of nearly 12 years, my lord. My lord, the FIR came to be filed on 17/8/2012.
FIR is not against you?
My lord, yes. My lord, when the FIR was first filed, my name was not there
Yes.
as an accused person. My lord, but the petitioner was working as assistant superintendent at that point of time, 2012.
Yes.
And in the year 2023, on 23/11/2023, prosecution sanction was accorded against me.
So during the investigation,
During
it was found that
investigation,
you were also involved.
I was
Case.
in
So
the year
prosecution sanction they have.
in the year 2020, my statement was taken,
Okay.
and 2023 prosecution sanction was
You retired in the
accorded.
year
I
2017?
retired in the year 2017.
Hmm.
And even after a lapse of nearly
But-
12 years,
Hmm.
11 years, 9 months,
Hmm.
the charge sheet is yet to be filed.
You are not even the name FIR.
Yes,
So
my
how
lord.
do,
My lord, I have annexed the
Crossing
prosecution
petition,
sanction.
how?
I have annexed the prosecution sanction as annexure 2 at page number 12, wherein my name has been indicated as an accused.
because this is subsequently your name was found involved. And then in the FIR, your name is not there.
Yes.
So
The
how
FIR
do,
was to the effect that 23 bogus pensions were detected. The
Yes.
FIR, yes,
And it was in your time, during your time, when you were still working. in
yes,
the-
my lord.
Yes.
Yes, my lord. But that does not imply that I have committed the crime. And
The matter is still under investigation.
yes, my lord. Yes,
So
my
then,
lord. My lord, to that effect, I have a case law.
Yes.
This infringes the valuable right of the petitioner, right to speedy trial and investigation, infringed in the Article 21 of the Constitution of India. So the case law is very clear to the effect that if the charge sheet is cannot be filed within a short period of time, it has to be quashed. The FIR has to be quashed. My lord, I'll just provide you the site.
where is the law, substantive law? Which says, in the trial, of course, in
My lord, my lord, may kindly come to page number 14.
page 14,
The page number is on the left side top. Page number 14.
page 14,
Yes, my lord.
para?
Para 6.
Para
Para
6.
6.
Okay, according to
Yes,
article.
my lord. My lord, I am allowed to read out. According to Article 21 of the Constitution, the petitioner is entitled to the right to speedy investigation in trial. The apex court and such, reported in 1992, Volume 1, SSC 225, has identified that right to speedy trial is the right of the accused. Reliance is also placed on such, 2009, Volume 3, SSC, wherein it was held. It is therefore well settled that the right to speedy trial in all criminal prosecution is an alienable right under Article 21 of the Constitution. This right is applicable not only to the actual proceeding in court, but also includes within its suite the preceding police investigation as well. The right to speedy trial extends equally to all criminal prosecution and is not confined to any particular category of cases. In every case,
whether the right to speedy trial is alleged, where the right to speedy trial is alleged to have been infringed, the court has to perform the balancing act upon taking into consideration all the attendant circumstances enumerated above and determine in each case whether the right to speedy trial has been denied in a given case. My lord, in this particular case, there was a delay of 10 years. So in the FIR was quashed.
Well, issue notice.
My lord.
So, acceptance, okay. But Mr.
Akakichu.
Learning Counsel for the petitioner also heard Mr. Jimomi.
Yeah, my lordship.
Sorry. Mangami was there, Jimomi was there. Mangami, Lana PP, Nagaland, no? Stop. Huh? Para. This is an application under Section 482 of the Code of Criminal Procedure, 1973, praying for quashing the impugned FIR being registered as a state crime cell PHQ C stroke number 05/12. This is 2012. Stop within bracket GR 179/12 bracket close under section 409, 420, 469, 468, 471, and 120B Indian Penal Code. Stop. Issue notice returnable by 4 weeks. Stop. As Mr. Yangami, Nana PP accepted notice on behalf of the state respondent, no formal notice need be issued to the said respondent. However, the petitioner shall provide a requisite extra copy to the learned. No, only one, only, not required extra.
I mean,
Okay.
we need.
Because there are the other department, okay, to the LANA PP during the course of the days. Stop. The petitioner shall also take steps upon the respondent number 2 by a registered post with AD within a week from today. Okay. List this matter after 4 weeks. Okay.
For motion, item number 46.
Please, my lord.
Yes.
My lord, this application has been filed under section 482 of the CRPC. Seeking the indulgence of this honorable court for invoking the inherent power for question the criminal proceedings in respect of GR number 155 of 2023 corresponding to Kohima North PS case number 54 of 2023, wherein a written FIR has been filed dated 16/10/2023.
This is under section 186, 341.
Yes, my lord.
506, which is non-compoundable.
Yes, my lord.
Which one?
186.
186.
My lord. Okay. My lord, there has been a settlement between the complainant and the accused person herein.
Complainant and the accused person.
Yes, my lord.
Where is the FIR? Let us see who filed FIR.
The FIR has been filed by the
Page 15.
Page 16. Registrar.
Registrar.
Nagaland University.
Let us register and then let us see the agreement.
Agreement will be on
Compromise
page 17.
17.
Yes, my lord. On the next page.
So where do we find the name of this Dr. Abemo who filed FIR?
No, Your Honor.
Yes.
This meeting has been held by the undersigned who are
where is the name of the person who lodged FIR in the agreement settlement?
Your Honor, he has been transferred after the incident, and then another person,
He is the
he
agreed
took
person.
charge.
He is the agreed person.
No, he is not the aggrieved person.
Then
my
who is
lord.
the agreed person then?
The aggrieved person is the provici of the Nagaland.
Where is the signature of the Pro VC?
Only his presence has been shown in the minutes of the meeting.
No, where is his signature?
His signature is not here in the settlement agreement, but his presence is there as well as.
It is him who is necessary to sign in the settlement. So who will sign on behalf of the agreed person? The injured person?
On behalf of the aggrieved
It
person, the
cannot be
finance.
delegated. Can it be delegated unless otherwise?
Your Honor,
Yes,
if I may be allowed to read the meeting minutes in that case.
minute.
Yes,
Okay.
it's only one page. A meeting was held on 21st October 2023 at the Kohima campus in the presence of VC, Vice Chancellor, Vice Chancellor. He's the victim.
Okay. But you see, the Pro Vice Chancellor is the person who is the agreed person, isn't
Aggrieved
it?
person. Yes, my lord.
But he need to sign what I'm saying. It will be difficult. His presence is required. What do you say?
Lordship, as per the Gauhati High Court
Because he's
rules.
agreed. It's a criminal case.
Lordship,
Yes,
Can't be delegated.
Lordship.
Lordship, but it has been done with his understanding.
Okay, and now come to let us tell him that one more
And he is
understanding.
not even the
Tell him
complainant
that
of the
one more
case.
understanding, sign it.
Yes, my lord. But he is not even the complainant of in this matter.
Then who is the
complainant-
complainant?
The complainant.
Register is
Registrar.
also not signed. Then
No, as I was saying, my lord, the registrar, after filing this complaint, he has been transferred, redesignated. So the new registrar in charge, after this compromise
so
settlement has been done,
if
he
it
has
is a
written
civil
to the.
case, then it's okay. But then it's a criminal case. He was the criminal action. The criminal offense was committed to the Pro Vice Chancellor. He need to sign. Ask him, since it is a to sign it. Then I think in the criminal case, you see,
My lord, in this matter,
accused.
the IO of the case
Yes,
has
the
even
accused also.
submitted the charge sheet,
Hmm.
wherein he has never mentioned about anything about the victim, alleged victim.
Charge sheet also filed.
Charge sheet has already been filed.
Okay. Against whom?
Matter.
Against accused.
Persons.
Saying what? Where?
It starts from page 19, my lord.
So must be for commission of some offense. Charge sheet.
As per the charge sheet,
Charge sheet filed for
he has
where-
clearly stated
let
that.
us see the last one. The last part, the operative portion of the charge sheet. Where?
It will be from page 21 onwards.
Page 21 onward. So
Last paragraph.
last C22, basing on the light of the above fact and circumstances, a prima facie case under section so and so is found well established against so and so. See? So what is, let us see, what is 186?
186 is obstructing a public servant from
341
performing his
confinement.
duties.
341 confinement. 506. Then obstruction was done to, or the confinement was done to the Pro Vice Chancellor only. How
Yes,
come?
my lord.
Then he has to be made party.
In that case, my lord, I may be given the liberty to file a petition.
What do you say?
Lordship.
Not necessary or what?
Lordship, as Lordship has rightly pointed out, as far as Gauhati High Court Rules 2022,
Yes,
chapter,
necessary.
yes, Lordship, chapter 14, Lordship, which says that a complainant as well as the informant is obligatory.
So here in this case, you say that informant register has been already been transferred because register, because he's a vice chancellor, probably on his instruction only, the register has filed FIR. So here, since the register has already been transferred, so this, in the criminal case, aggrieved is the vice chancellor.
But
Against whom the offense.
my humble submission, my lord, is that in the amicable settlement,
Okay.
the very alleged victim,
Hmm.
he is present in the meeting, and then with his due consideration, the
He should have
settlement
signed
has
actually.
been.
Since there was an amicable settlement, just ask him to just sign it.
Lordship.
So then we'll see whether it can be passed or not. No? Okay, you filed.
I may be given the liberty to file afresh.
File?
Afresh.
Afresh?
Yeah.
Okay.
Fresh petition.
That will be better. Yes. Now, counsel for the petition, Mr. Akru Joshi. Praise for allowing him to withdraw this criminal petition with liberty to file afresh, if so advised. Stop. Mr. Jimomi, Dana PP is present. Stop. Is prayed. The prayer of the petitioner is allowed. This criminal petition is dismissed on being withdrawn with liberty is prayed for. Okay.
Oblige me.
For admission, item number 1.
Lordship.
Yes.
Lordship, has per court order 18/3/2024. I was instructed to place on record the order bearing law APPT-18/16/67 dated 6/7.
So order?
Lordship, has per court order dated 18/3/2024.
18/3.
Lordship.
What it says?
I was instructed to produce
Okay. Instructed to produce what?
order bearing law such and such dated 6/7/1983 and
Have you produced?
Lordship.
Have you filed in the form of affidavit?
No, Lordship. Kindly let me to place this on record.
Place it in the form of affidavit. File it.
Lordship.
Okay. In the newspaper, we will not be able to accept it. File it in the form of affidavit. Okay.
Lordship.
Miss.
Pichano.
He's present, maybe record. Mr. Lana counsel for the petitioner is present. Stop. Miss, you are for respondent? State respondent?
Lordship.
Okay. Lana counsel appearing on behalf of the state, submit state as per the direction of this court on 18/3/2024. He has obtained the necessary documents. Necessary for the to place on necessary document to place on records, and praise for allowing her to file the above records, that is order bearing number APPT 18/6/67 dated 6/7/1983.
Lordship, there's a typographical error in the typing.
Okay, then okay, necessary praise for allowing her to place on record the above documents in the affidavit form. The prayer is allowed. List this matter after 2 weeks.
3 weeks, Lordship.
3 weeks, after 3 weeks. Okay. In the meantime, you'll file. Okay.
Lordship.
For admission, item number 7.
6, someone mentioned? Yes. Mentioned, no?
6 on 17.
This is
Item number 7.
Okay. Yes. Who is for the respondent? Yes.
Lordship, on the last occasion, this honorable court has asked whether the petitioner has filed challenged the imping order, which I have challenged before this honorable court. Lordship, the petitioner has filed a petition of condonation since the Honorable Civil Court failed to consider the period which has been excluded by the Honorable Supreme Court due to COVID pandemic, Your Lordship. However, the Honorable Civil Judge, Senior Division Dimapur, failed to consider that period and did not dismiss the petition for substitution. Yes, Lordship.
Okay, so
So the
respondent has also filed affidavit.
yes, Lordship. Lordship, there is three respondent. Two respondent has been is appearing. The another third respondent is not appearing, Your Lordship.
So what do we do
However,
with that?
Lordship, even in the civil court, the third respondent is the proceeding is the case
Did
is
not
taken
appear.
up. Yes, yes, without the third respondent, Lordship.
Who is this third respondent?
He is the one who bought the disputed land.
Okay, his presence will be required then.
However, Lordship, in the
He's a third party interest.
yes, Lordship. So he's not appearing even in the civil judge's court also, Lordship. I have served the copy.
He has
to
received the
register-
copy.
Yes, I have served the copy to registered post, Lordship. To the yes.
Whether returned? Awaited. What do you want today? Respondent not appearing.
Lordship, I think the respondent has missed out the cost list listed today. So if the matter can be taken up tomorrow, Lordship.
Tomorrow.
Yes, Lordship.
Okay. He is prayed for by the land council for them. Tomorrow, no, next week. Tomorrow is Friday. I think list already prepared for tomorrow. He is prayed for by the land council for the petitioner. List is matter next week.
Next week, if Lordship can be given a specific date,
On
yes,
Tuesday. Tuesday.
Lordship.
Okay.
Much obliged, Lordship.
For admission, item number 23.
Yes.
Lordship, last occasion, updated city has been called for.
CD was called for.
Yes,
No, no,
updated city, Lordship.
then certain documents.
Yes.
First document, Lordship,
ask
the
for what?
agreement, in order to set up
The
the
agreement and the postal return.
Lordship.
So is it available?
Lordship, I have also been informed that the charge sheet has been laid before.
Already laid?
Yes, Your Lordship. Regarding the legal notice, Your Lordship will find that page 8.
There is no stay, I think, here.
Lordship,
There is no stay here.
this bill application.
It's
Oh,
a bail
sorry, this is bail
application.
application.
Yes,
Okay.
Your Lordship.
Okay.
Yes,
So charge sheet filed on time.
yes, Your Lordship.
So
Within time, Your Lordship.
within time.
Oh.
Yes.
So that
Page-
means, Your Lordship, there is the prima facie case make out, Your Lordship. So this bail application will not be maintained.
No, Lordship. Merit application is different and bill application is different.
Otherwise, Your
what did you
Lordship
say?
may consider on the available material, Your Lordship, as per the statement of the CD.
CD,
The CD, Your Lordship, on the
in the
last
CD
occasion,
charge sheet is
already-
available.
No, Your Lordship, it is just.
Then
a
it's better for,
statement. It is just a statement under 161, Your Lordship.
161. Then since
It-
charge sheet, we could have produced charge sheet. If it has already been filed.
Your Lordship, let the
For
petitioner
consideration.
contest. Yes. At CC hearing, Your Lordship, let the petition contest.
No problem,
Because there is a
Lordship.
prima facie case.
No problem, I can contest. However, Lordship, this is bill application, so this honorable court may consider this bill application first.
Your lordship, once the
So
charge,
contests the trial, lordship, that is different
once the
issue.
charge sheet is filed, it has to be
There's no bar
considered
to
on
consider the
merit,
bill
your lordship.
application after filing the charge sheet. But then at the time of filing this application, lordship, I was not aware whether charge sheet was filed because I'm under custody.
Lordship, this application is under 439. It's not under 1672. So, your lordship. Legal notice has been served to them, your lordship. That is evident from the document, the extract document.
So, see, the notice seems have been served upon the accused and then it has returned. So postal report also says that not delivered, no such person in the address.
I've not
And
received the
if
legal
it is
notice.
a company, no. If it is a company,
Lordship.
so
I don't know
in the
which
address, and
district.
if you are working in that company, Ranadeep Nagar, this is upper thing, represented by his CEO, Amol Tong.
I'm the CEO, Lordship.
Amol Tong.
Yes.
So address seems is correct. But then the not delivered, no such person in the address. And here also, so there's something.
Through WhatsApp also we have sent, I mean,
Yes,
the company
something
yes.
through WhatsApp.
Yes.
Where it is?
Page 5. You know, should we kindly
Warrant you
turn to
answering.
page 5. It has been received by one of the co-accused, your lordship, Pratik.
Page 5.
Page 5, your lordship. Your lordship, I'm sorry, your lordship, page 7, your lordship, page 7.
There's something. So why don't you produce the charge sheet if it when it was filed?
It was, I'm informed that it was filed on 29th of this
Can you
month.
produce it tomorrow?
Your lordship, that will be difficult.
Where it is?
Dimapur.
Dimapur.
Yes, your lordship.
Monday?
It has to come through
Because it appears that there the notice was and in the message also it appears that he is not responding and try to avoid. It appears. So I just would like to see before passing.
Otherwise, your lordship may kindly
consider under the circumstances, then I have to reject only. There is a prima facie case against him.
Yes, your
Lordship, me kindly.
now he is accused.
So
the allegation is cheating.
That is make out, your lordship, from the CD. If you can your lordship may kindly
And
the
by
statement.
filing the complaint, the complainant wants the money back or the mission. So Lordship may kindly consider by lodging the petitioner and custody, how he will get the money back, or For that matter, to mention.
Yeah, that is true. That is true.
Don't
That of course I
look at this
understand.
unnecessary
So that's why I
harassment.
was trying to consider a case.
Yes,
But then it appears that the address, I wanted to confirm whether this firm or the company is in existence through or the.
Lordship.
So, but it appears that from the message also, he was sent all these through message also, it appears.
Yes, your lordship.
So
From the
now he's
message-
saying that it's a proprietary firm. I'm not a partner. Now he's trying to say something and then he switched off also. And then switched off, couldn't contact.
Lordship, they are lying,
And now
your lordship.
his
And
reply started changing.
yes, and if your lordship would see their statement, they also admitted that they have lied, your lordship. That shows that 420 is clearly established, your lordship. Cheating.
And then the address seems correct.
Correct.
And the return postal report also says not delivered because person in the no such person in the address. And then this postal remarks is also there.
Yes.
So under the circumstances, it appears that prima facie case made out. Otherwise, you see,
Yes.
if there is agreement, 50% he agreed, whether legal or illegal, whatever may be, I was trying to just, if he had agreed, then he has to pay, I thought. But then it appears that he's trying something, doing something, it appears.
Yes, your lordship. It is just
So where is the statement?
The statement is at page 10, your lordship, of the CP. Page 10 of the scanned.
So this is Amol.
Amol. Amol.
The
County.
operative person.
That allegation, that
Your
will be
lordship.
proved after the trial, Lordship.
Right.
That is we are in bail, Lordship.
That is true.
But
And
your lordship,
considering that he's from the outside, outside farm, and trying to dupe, and trying to, you see, probably it appears that from this may not be, but then it appears that he's trying to avoid and then shown
Yes.
the farm or the company of some other person when this person came. So if that is so, then the prima facie case made out, and then it will be difficult for the state police to find him again.
yes.
Just a minute.
Once,
Just a minute.
even after filing the charge sheet, bail can be considered.
Right,
That is
right.
the law laid on by the apex
So
court.
where is the statement?
Page 10, your lordship.
Then
He failed
entire.
to state, the entire may be read, your lordship.
Okay.
Yes.
So he deliberately, you see, he now is admitting that because of some problems, he had some problem, and because of that, he had to tell lie, and he deliberately.
That is the statement before the police, Lordship.
But that is relevant for consideration of bail, your lordship.
So how many of them are there? Only one.
Two of them.
The
Two
bill
of them.
application has been filed by
Arrested
one
2%.
only one person.
Only one person.
There are two accused, Lordship.
Yes.
But it appears that there is prima facie case against
Yes,
him.
yes, your lordship.
As per the submission of my learned friend, Lordship, charges already filed.
How long he has been?
71 days now.
71 days.
It's filed within time, your lordship.
Yes,
90
within
days.
time.
No,
within
that is
time.
that is different. I'm not on that.
So now, within a,
once- yeah, it
since
has to be
he's inside, the charge
Yes.
can be framed against him.
Yes. Yes, your lordship.
And for your Lordship satisfaction, I want to refer only one judgment.
Yes.
Lordship, 2000,
No.
regarding the filing of charge sheet and release of the accused
Mm.
and such cases. 2012, one is CC. 14.
This can be released, of course, but you see,
Only one paragraph, Lordship, with regard to filing of charge sheet.
yes.
Other conditions, in principle, has been laid down how the bail has to be considered.
Yes, Clara.
But Lordship, paragraph 46, page 64.
Yes.
May I read, Lordship?
Yes.
We are conscious of the fact that the accused are charged with economic offense of huge magnitude. We are also conscious of the fact that the offense alleged, if proved, may jeopardize the economy of the country. At the same time, we cannot lose sight of the fact that the investigation agency has already completed investigation and charge sheet has already been filed before the special judge CBI New Delhi. Therefore, their presence in the custody, Lordship, their presence in the custody may not be necessary for further investigation. Investigation completed. We are of the view that the appellants are entitled to grant bail pending trial on stringent condition in order to allay the apprehension expressed by the CBI.
Yeah, that is true.
My learned friend is, her submission is that there's prima facie case. I'm not on that issue, Lordship.
Based on the
Whether the
material.
Honorable Court
Based on the material.
is the authority to
All the
consider
thing,
bail or not,
of
that is
course,
the issue here.
ensure his presence, of course. So,
There is no dispute,
Lordship,
as per the
allow-
submission,
Lordship,
charge sheet
allow
already
me to
filed.
raise this. Strikes. The money received acknowledged by Pratik, your lordship, the co-accused. In the name of the firm, the money has been deposited, he acknowledged, and now he's saying that he is not a part of the firm.
The petitioner?
So this all,
Petitioner?
it is the co-accused Pratik.
Petitioner now. Who accused? Who accused to him? He is not a petitioner.
he is Pratik.
Pratik, yes, your lordship.
He is not a petitioner here, Lordship.
He is not a petitioner, but he has been receiving money on behalf of the firm. Your
I don't know, Lordship.
And now, your lordship, he, from the text message, your lordship would see that he is lying, saying that it's a proprietorship firm.
That is to
So
be broke by
on
the,
one pretext or other, they keep on lying, your lordship.
that,
And they
that
have,
has to be broke by the
they have been in
not by the
touch to
petitioner.
WhatsApp only, your lordship, after the agreement. And if your lordship would see the WhatsApp messages, they keep on changing their statement. They will say that a consignment will reach on certain date. Again, they will avoid the
It is
post.
not a trial
And
stage, Lordship.
it was
This is bill
never-
application.
No, but for consideration.
We are
your
not on
lordship,
trial, Lordship.
It has to be, your lordship. All this has to be taken into consideration, your lordship.
Where from they were arrested?
They were arrested from Mumbai, your lordship.
Mumbai.
on the strength of NBWA.
Lordship.
Lordship.
So then, on Monday, can you produce the charge sheet?
Your Lordship,
Just would like to see.
it has
If
already been filed before the Judicial Magistrate First Class. So LCR may be called, Your Lordship, through registry.
Okay.
Yes.
So we'll just see. Since she has submitted that charge sheet already filed, so in that case, we need to.
Lordship, in view of the urgency of both Lordship, since the accused, the petitioner is under the custody for more than
Yeah, that
17
is right.
days.
I
So,
was also under the
your time-
impression that since there was this is an agreement, more or less it was a civil case, civil nature of case. But
Yes,
then you
Lord.
see on perusal of these records, then it appears that they are trying something.
Yes.
Okay.
So Lordship, lower court record will be called for.
Yes. Mr. Jamir, learned counsel for the petitioner is present. Stop. Ms. Esmeren,
Tuesday,
while producing, Lana PP, okay, while producing the document sought for on document sought for by this court further submits that in the meantime the case has already been charge sheeted, submitted into charge sheet before the landed CGM or JMFC. It should be CGM. JMFC.
It's I'm informed that yes, it's before JMFC.
JMFC.
Yes.
It has to be before CGM. JMFC.
That's what I've been informed, Your
let
Lordship.
my learned friend.
By the
Second
IO, Your
same
Lordship.
person.
That's what
Okay.
I've been informed by the IO.
Okay.
JMFC.
JMFC. No?
Yes.
Before the JMFC.
Mm.
Which one?
Dimapur.
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 Stop. And JMFC. Stop. And she may be allowed to produce the same. So call for the is record of the call for the case record, from case record stuff. List is matter on Tuesday. Okay, Tuesday again. On which date Ms. Mary Lana PP shall produce the case record of the above PS case. Okay.
Obliged.
From the supplementary cost list for admission, item number 47.
Lordship, we are in the verge of settlement, Lordship, of the issue. We are on the verge of settlement.
Okay.
Of the issue, and the petitioner will be making a payment, the final payment, within 2 weeks, Lordship.
Okay.
He is in Delhi, and Lordship, after that, Lordship, compromise deed is intended to be signed after the entire payment is met.
Okay.
Which we will be placing on record of this honorable court, and on placing on that, Lordship, this honorable court may consider whether to quash the FIR and close the case based on the compromise, because these are compoundable offences, Lordship.
Okay.
As such, Lordship, I pray that the matter may be listed after 3 weeks, Lordship.
Okay.
That is 2 weeks for enabling the payment and 1 week for making the compromise deed, Lordship.
So that is in between the parties only will not.
Yes, Lordship.
Okay.
Lordship.
So, Mr. Santianger, Land Counsel for the petitioner, and Mr.
Akam,
You are for?
I'm for respondent number 2.
Okay.
My lord,
Mr.
my
Angam.
learned friend submission be recorded.
Yes, Lord.
Is it?
Yes.
Okay. Mr. Who submits that this is regarding non-payment.
Yes, Lordship.
Hmm.
There is a dispute
the
regarding
matter-
payment
matter-
and non-payment of money,
Matter,
Lordship.
okay, matter is under the verge of settlement between the parties. Settlement between the parties. Stop. The who agree to pay?
The petitioner shall be paying the respondent number two. The final payment of rupees 1,75,000 within 2 weeks, Lordship.
Okay. The petitioner would be paying the remaining amount of 1,75,000 to the respondent number two within
2 weeks.
Within 2 weeks from today.
Yes,
From
Lordship.
today.
Yes, Lordship.
From today. And
after that, Lordship.
and thereafter the agreement will be
yes, a compromise
thereafter,
agreement.
the compromise agreement will be executed between the parties. And praise for listing the matter after
3 weeks.
3 weeks. Staff. Mr. Okay. Mr.
Akam Jamir.
Land Council for the respondent number two. Okay, then Mr. Angamia, Land Council for the the state respondent and Mr. So-and-so for respondent number two are also present. Staff. In view of the above, and has raised no objection. Staff. Has prayed for the Land Council for the petitioner list this matter after 3 weeks. Okay.
Obliged. Deeply obliged.
For orders, item numbers 33 and 34.
No one appears on behalf of the. Oh, so 33 and 34.
Yes, sir.
Okay. So this is for. Are we taking steps?
Yes, my lord, I've taken a step in complying the order dated 4/4/24.
4/4.
Yeah, April 4/24. The Supreme Court have directed me to issue notice for the registered post.
You have taken steps.
Yes, my lord, I have taken the step.
So no one is appearing. Whether they have received their notice.
Beg your pardon, my lord.
Whether they received the notice.
That I have no idea, my lord, because I have sent to the registered post.
Okay, what do you do then?
Through the court registry.
This is IA.
IA 9.
IA 9
of 24.
Okay, Land Council for the applicant, Mr. You are Mr. Lejon. You are Mr.
Reachable, my lord. Reachable, my lord.
No one appears on behalf of the respondent. What do we do? There is no office note also.
My lord, this the petitioner in the criminal revision have willfully not complied with the honorable court direction. We have executed a joint affidavit that the petitioner will pay me all the remaining due on 5 installments. But but almost all the check have balls. All the check were disordered. For that, I filed two IA, IA6 and IA9, bringing on records to the check balls.
So last time, who appeared on behalf of the respondent?
The previous lawyers, they have withdrawn their Bangla number.
Oh, previous lawyer,
Yes.
advocate for the appellant. Sorry,
Yes.
petitioner.
Petitioner in the
Withdrawn.
criminal revision. They have all withdrawn their Bangla number. But still in the court list, the registry have given their name.
The complainant was also present in the last occasion in person.
Yes, on 2012, 2024. The order 2012 to 2023 and 14/12/2023. They based on that order they executed a joint affidavit.
Affidavit and reply filed on behalf of the respondent. What do we want now?
My lord, if you're maybe pleased to dismiss the criminal revision petition.
You are for?
I'm for the respondent in the criminal revision, but I filed a criminal complaint before the CGM gave free.
So no one is appearing on behalf of the criminal revision petitioner?
Yes, now for the last two occasions, no one have appeared.
Just a minute, the instant revision. Oh, this is quasi petition.
Yes, my lord. The learned court below had issued non-billable arrest warrant. Also, the criminal revision petitioner have approached this honorable court to suspend the non-billable arrest warrant, and the proceeding of the criminal complaint
suspended
is stayed.
Stayed?
Yes, stayed. And the non-billable arrest warrant was also suspended. So now, unless the proceeding, the stay of the proceeding is vacated, I have no other remedy. And my lord.
So it was under the in the process of negotiation between the parties. What happened thereafter?
In fact, my lord, both the parties have executed a joint affidavit.
Joint affidavit for what?
Yes. To pay all the remaining dues. The respondent.
The revision petitioner were to pay.
Yes, because
did not pay thereafter.
No.
So now in the process, he probably has undertaken before this court also.
Yes.
Then what do we do? Do you want this case to be dismissed?
Yes, my lord. With the direction to the learned court below to proceed with the case.
The case is under offense under section.
You're cheating, my lord, 420.
420.
Yes, my lord. The complainant has filed a criminal complaint.
This criminal revision joint affidavit before this court. Earlier, we have filed joint affidavit also.
Oh, yes, my lord.
What is this?
Joint
This is,
affidavit, my lord.
this is filed before this court only. So petitioner was to pay some around 51 lakhs
Yes, my lord.
to the respondent, to you.
Yes, my lord.
So then thereafter, he has given a post-dated check. So that
Yes.
according to you, bounced. That post-dated check.
Yes, my lord. Yes,
It was to be presented on the month of December only. So you presented.
Yes, my lord. Fourth check already bounced, my lord.
Okay. So then initially when it took the undertaking that the post-dated check shall be honored. So on such prayer made by the Honorable Counsel for the petitioner, then this court stayed.
If I may, my lord, on 26 to 24, the Honorable Court have given the petitioner the last opportunity to honor the remaining two check.
On which date?
On 26 to 24. 26 to 24, the Honorable Court have given last opportunity to the petitioner to honor the remaining two check. But despite that order, another two check were
In which case? In IA?
in the main order, my lord.
In the main, 26?
To 2024, 26 to 2024.
No, in the main, no, in the main, the order is only up to 12/12.
Yes, in IA 6, my lord.
23 only. IA 6. Sorry.
Yes, IA 6, my lord.
Yes, 26. This IA 6 was filed by whom?
Filed by me, my lord.
Okay,
Because
saying what?
the first,
This was filed for what?
in bringing in the court report that check dated 2012, 2023.
To be withdrawn in the December.
Yes, and 10 January 2024.
The 26(3), it was, this is only allowing Mr. Pumpkin Richard to file IA only. (26)(2).
Yes, my lord.
This is 3, this 26(2). Okay, just a minute, huh? So 2 checks were issued.
No, 5 check, your order.
No. As per this 26(2) order. Both the checks were dishonored. Three checks are not presented before the bank. Why?
Lord, after the 2 check were dishonored, I filed IA 9. So the dishonor of 4 check is already put on record, my lord. IA 9, the check dated to 31/24 and 21/2/2024. So for dishonor check,
This IA 6 is for what?
IA 6 is the first 2 check which were dishonored.
Okay, so this, to bring those,
Yes,
that
yes.
on record,
Yes, my lord.
only to bring that on record.
Yes, my lord. The order dated 14/12/23. The dishonor court
Order
gives the
dated?
liberty to me to bring on
Order,
record.
order dated?
Order 14/12/2023.
Of?
Dishonor court.
As in the main case?
Yes, my lord. Have given me the liberty to approach dishonor court by filing IA, bringing on record the dishonor check.
So in the last occasion, Ozukum appeared for the respondent. Okay, so this, and then this IA 9 is for?
IA 9 is filed to bring on record the check dated, which were dishonored on 31/24 and 21/2/2024.
3 checks.
To check.
To check.
Yes, ma'am.
Okay, what we'll do, the respondent is not appearing, so you'd bring this entire, when you were presented a check.
Yes.
On a, given a check, and then you presented and then dishonor,
Yes.
you bring it in the list of that form, list of that, that when they failed.
Yes.
Okay, so we'll dispose of on Monday. Or tomorrow, if you can.
Next week.
Let us give one more chance to the petitioner.
After a week, my lord.
Next week, what?
Yes, my lord.
Tuesday? When, when?
13.
Chronologically, you're just giving a small sheet.
Okay, my lord.
Small.
In the form of additional affidavit.
May not be. Or if they have, because in the last occasion, it seems that the advocate withdrawn.
Yes, my lord.
It appears. So that also you bring on record.
Yes, my lord.
Okay. So because this was in the oral column, and then it only the step was to be taken, I also did not go through the entire things. So that is why. So you on that day, you update when? Tuesday? Or when? State has also been made party here. State has also.
No, my lord, no, my lord.
No, okay.
No problem.
Mr. This is item. 33, 34. Mr. Suku,
Okay, it's over, my lord.
in the IA. Okay, learn counsel for the applicant. No, who, 33. Okay. 33, IA is in, okay. No one, IA, you have filed, no? Okay, learn counsel for the applicant is present. No one appears on behalf of the respondent revision petitioner. In absence of the respondent revision petitioner, the case stand adjourned. List this matter again on Thursday. We'll say Thursday, huh? Next Thursday. When is next Thursday? Okay, 9th. Okay, on that day you come prepared with all those facts. Okay, my lord. Okay.
I'm sorry, your lordship, I beg your lordship indulgence in item 23, your lordship. Your lordship here, your lordship LCR may be called through the registry.
Through the registry?
Yes, your lordship.
Okay, call for. 23, have you noted? Oh, okay. Call for the LCR through the registry, huh?
And the matter may be listed as and when the LCR is received, your lordship, by the registry.
Direction may be issued to the registry to expedite for noticing the city.
Okay.
In view of a long
okay, the call for LCR, huh? Since the matter is shown urgency.
Section 9, lordship, instead of 7.
Okay. The registry shall, sorry, call for LCR, huh? Through registry. Okay, since the matter has been shown urgency, the registry shall expedite the correspondence or what? Registry shall send through, it is sent through the message only.
Whether it will be sent in original
how it is called?
That, your lordship, the registry will have idea regarding the calling
How
of
they
the law court record.
2-3 weeks.
Nowadays, a
No,
scanned
the
copy
three,
can
it
be
will
made
expire.
available, right?
A call for a scan copy of
copy,
LCR, then
yes,
scan
that
copy of LCR.
Records of GR case number 47 of
yes.
24.
LCR.
Yeah.
GR 47 of
That
24
is GR 47.
from JMFC, Dimapur.
From JMFC. Dimapur staff, huh? Okay. Then then the fixing date will be not 7, instead of 7, it will be 9. This is matter again on 9th. Okay.
Grateful, Your Lordship.
Obliged. For hearing item numbers 36 to 39.
Oh, this. What was to be, okay, you were to be heard. So hearing in respect of the petitioner and the respondent, state so respondents are, you have anything to, any more to submit? Concluding submission is also there. Okay. So now, respondent number 1 to 4. Okay. So now, it is respondent number
6 in WPC 58 of 2017, Lordship, and contempt petition 23 of 2022. I'm for
6 in
respondent number 6 in WPC 58 of 2017. And respondent number 2 in contempt petition 23 of 2022.
Okay, so your private respondent in respondent number, private respondent in WPC 58.
Lordship.
So, but not in WPC 88.
No. I'm not implemented in 88 and 207.
207 is also there. Okay, 207 is the older one, I think.
Lordship.
It was filed earlier, much earlier. 207 is against whom?
Lordship, against the order passed by the head Tobashi.
Okay.
Directing my.
Whether the head Tobashi is participated or is contesting the.
Head Tobashi here, it is, they are not. They are not. Since they fall under the administrative setup, they fall under the Deputy Commissioner's office. So an order passed by the head Tobashi is in the under the letterhead of the office of the Additional Deputy Commissioner.
So here they are not contesting.
No, they are not even.
Who else is the party in that?
The Additional Deputy Commissioner did it.
Okay, the state.
Yes, in the court of the.
Okay, state. Whether the state has filed affidavit in that?
State has filed affidavit and exhaustively argued on it on the other day. In this, in the other one, no.
No, not in 207.
In 207, no affidavit has been filed.
No affidavit. Yes. No affidavit.
No.
So how it is connected with this?
The
88, 50.
The main case is that
88.
Land, yes, the land is.
If 88, it depends on 88 only.
88 only.
Okay.
88 and they are more or less same because the order has been passed. Orders has been passed in these both the cases by the.
Okay. Okay. Let us keep it aside for the time being. So now while writing,
yes,
I'll be needing how it is connected later on. Huh?
You're right.
Not now. Just a minute.
Yes.
Now in the 58 will 58 for your side. I mean for you 58 also the submission would be same.
Your Lordship, more or less same because my case is that while the matter is pending inquiry.
How it is connected with
yes, Your Lordship.
Private respondent in 58.
Yes, Your Lordship. What happened in 2011? It so appears that in 2011.
Just a minute. So
yes, in 2011, Your Lordship, it so appears that the land which is in my possession without my knowledge was allotted to the private respondent
by the government.
By the ADC.
2011.
Yes, in 2011. So that is challenge, Your Lordship.
So say impugn order.
It is. Question set aside impugned illegal land permit dated 15/5/2011. Your Lordship, the private respondent has filed the affidavit.
Just a minute, no, your part. So where is the impugn order? Just show me once.
Your Lordship,
The impugn order. Here in
there are two impugned orders here. One
in
is,
58.
yes, 15/5/2011 that I have not, it is not annexed here, but it is mentioned in the, impugned, last impugned order, Your Lordship. Yes, in this summons, Your Lordship, page 39. A permit has been mentioned as
58.
Yes, page 38, in 58, yes, in my petition.
38 is?
Page 39, yeah. Is the stay order in the earlier case, 207.
No,
This
58.
Page 38 is the stay order. The interim order passed in the earlier petition, the Lordship, that is 207. Now 39.
No, so earlier petition, earlier also filed petition.
Yes, that
For what?
207K of 2016, Your Lordship. In this case, the DB's order was stayed. Now, when that matter is still going, when this petition is pending again, in this case, the DB's court again, the DB again passed this interim, passed the impugned order against the present
No,
petitioner,
where is the impugn order?
which is at page 40. There are two records that are impugned.
Just a minute.
Yes.
So while this, there, the stay order was still.
Yes, in the other case, these are separate cases, Your Lordship, but pertaining to the main issue, that is the land, which is
Impugn order is it?
yes, impugned order is page 40, the second impugned order, Your Lordship. This, I am aggrieved by this, Your Lordship. Order dated 13 April 2017. This is in the court of TB's, Office of the Additional Deputy Commissioner, District, Nagaland. Mr. Wang Tun.
No, so the impugn order was, sorry, the stay order was passed on. So while the stay order was still.
But then these two cases are separate, Your Lordship.
Oh, separate?
Yes, Your
It's
Lordship.
not connected then?
No. These have a if I go chronologically, they are all interconnected. But what happened was, this honorable court directed in the 104 in the judgment passed in 2013, Your Lordship, which we have, which is at, this is 204 of 2012. The judgment dated 5/8/2014, which has already been discussed, but I'll take Your Lordship to that, page 20.
20 of?
Page 20 of the present petition also. In this 58 also, yes. I have annexed that judgment. Because what happened in that judgment, the honorable court directed that the special inquiry be conducted by the deputy commissioner and then submitted to the chief secretary for final decision by the chief secretary. That was the direction in this particular case. Now, inquiry was conducted and the matter was still going on. And what happened? While the matter is still going on in the interim, one order was issued, which is impugned here in 204, 207. That order was issued by the ATC, by the head TBs, directing some persons who are in occupying land which the petitioner has allowed them to occupy.
What was the direction of
So,
Tobasi?
the Tobashis directed them to vacate the land. So
here
agreed
we
by
have,
that,
here in this connection, in connection with this land, we have
Yes.
three authority. One you claiming to be owner,
Yes.
one Tobasis, and one government, isn't
yes,
it?
this is what is going on. The Tobashis could not have issued such orders. They had no authority, Your Lordship. If at all any order is to be issued, it is the additional deputy commissioner. But without even
a lot of things has
yes,
included.
so many
So-
illegalities are going on here. So because of that, I approached his honorable court, stay order was granted in that case. While this
Now,
was
research
going on
would be required
again,
here.
yes, while it was going on again, the TBs again issued the present in the order.
So because earlier it appears that
February-
you have filed this 207. 207, 2016, whether disposed of?
It is part of the pending case.
It is also pending.
Yes, it is still pending. It is to be taken up together with this one.
Okay. So, okay, 207 is yours.
Yes. So this order was issued against some of those persons.
And then you referred this, just now you referred.
And then-
some other order.
Then
No,
again,
204 also you referred. So what about
yes,
this 204?
in this 204, what happened was the story is like this. 1971, petitioner's father was granted a special permit. 1975, it was upheld by the administration that he has a right of way, no one can encroach into it. To 1996, the chief secretary directed the deputy commissioner that the chief secretary wrote to the deputy commissioner saying that this was a special permit granted to the petitioner's father because of his services to the state in times of need. You could not, nobody can allot land without the consent of the
commitment is to be honored.
petitioner and his father. So since there is report that encroachment is there by government and also by private individuals, a special inquiry be conducted and then submitted to the office for appropriate direction. That was the letter in 1996. The deputy commissioner's order is very clear to the district administration. No action was taken. The petitioner approached his honorable court by way of the 204 K of
204.
Yes,
204 disposed of?
204 K of 2012, which was disposed of, yes.
Okay,
Which
saying
is
what?
disposed of, which, yes.
What direction?
Whereby this court also held that, yes, the chief secretary has given clear direction to the district administration to submit report. So the district administration was submit its report and the chief secretary will take the action within 2 months. That was the order in 204. Now in 2014, the special inquiry was conducted, report was submitted. No action, no decision has been taken during that time. No decision was taken now. Then in 2016, this
207.
Yes, 2007, while the matter was pending like that, that so-called Tobashis issued these restraining orders.
Okay, so
So many
this 207
restraining
challenging
orders.
the Tobashis
Yes.
order.
So I have challenged that I have impugned that
Okay.
before this honorable court by way of this 207.
Okay, then in that
And
case,
what happened?
stay.
The order was granted.
Okay.
Now again, while that was going on, again in 2007, the TBs issued another order, which is impugned herein, in favor of the private respondents over private respondent.
DB.
Yes, the TBs again issued this order against me, because this land I had allotted to one missionary, and he had constructed a residence over there. The private respondents were claiming that it is land allotted by that plot on which the missionary had constructed a building has been allotted to the private respondent by the additional deputy commissioner way back in 2011.
Okay.
So
this
based
is about,
on that,
so this is about 58.
yes, this is about 58. So based on that, the TBs directed the person, the missionary, to vacate the land. So I have challenged the so-called the permit, land permit granted to the private respondent, as well as the order passed by the additional deputy commissioner. In this case.
Okay. So
then what happened? Into the 88, the last the matter which was argued before your lordship on the last two occasions, that case arose because ultimately in the deputy commissioner as well as the home commissioner decided to cancel the special permit granted to the petitioner's father. So I have now in the WBC 88, I am challenging the final orders passed by the deputy commissioner and the home commissioner as unconstitutional.
how many private respondent? Okay, private respondent number 5 only.
Only. And the private respondent, this is the only case where a private respondent is involved.
Okay, so you were allotted by the ADC by allotment order.
Lordship.
Where is the?
Lordship, I may make my comprehensive submission, Lordship,
Yes,
if I may be
yes,
allowed.
okay. Just a minute. Your impugned order in the 58 is?
And that she will be submitting that allotment order. I have impugning it. Since I don't have the copy, but it is to be found mentioned in page 36. Page 36. Sorry, this is no. Page
36 is report only.
Yes. Page 39 in this summons, the permit granted to the respondent is to be mentioned, is to be found mentioned. I don't have a copy of this. Because of that, I have only challenged this one without annexing the copy.
Okay, yes. Now, please take it.
May I please, your lordship?
Yes.
Assuming but not admitting, it appears that there till Monday there was only two owners, that is the petitioner and the government. Now today, it appears that another ownership comes in the form of the Nobashis, wherein they are pleaded in the petition number 88. However, lordship, I may be allowed to make my brief submission.
Yes.
About 10 minutes, lordship. Now, lordship, I am respondent number 6 in WPC 58 of 2017, wherein a contempt petition also rise up in contempt petition 23 of 2022. Lordship, the respondent number 6 is a union called the Mongu Union, comprising of more than 18 villages, comes from near the Dizit town, where the disputed land is located. Now this Mongyong Union, which comprises of 18 villages, were implemented in this ongoing petition only in the year 2022 by order dated 19/5/2022 in IA number 61 of 2022. Now that is how I come into the picture only in 2022, Lordship. Now,
No, you, so this is of 17.
2017 petition. However, respondent number 6, that is the Monyu Union, is completed only in the year 22 by order dated 19/5/2022, Lordship.
So, you are representing respondent number
6 in WPC 50.
And then 6, it was only after 5. Now you have been implemented as respondent number 6.
In through IA 61 of 2022, Lordship.
Okay. 19/5/2022.
Lordship.
Okay.
Now, Lordship, a portion of land measuring an area of 80 by 80.
Just a minute, huh?
Lordship.
This Monyan Union, Tijit Town. So you are representing this
Monyan Union, Lordship. Which
Union.
Lordship.
Union is represented by
the President, Lordship. The President.
President.
Lordship.
Have you filed affidavit?
Lordship, I have filed.
Okay, so these comprise of 18
more than 18 villages coming together and form this union, Lordship.
Okay.
Villages nearby this visit town, Lordship.
Okay, so originally it was up to respondent number 5 only.
5 only initially, Lordship.
Head Dabasi. Whether head Dabasi has also contested this.
No, they have not.
They have not filed.
They have not.
So ADC and but then who has filed affidavit? The respondent number 6 and
The state respondent.
state and the respondent number 6. Okay. Yes.
Now, Lordship, now a portion of land measuring 80 by 80 was allotted by the state, bearing site number 110611, dated 15/5/2011, which I've also annexed in my affidavit, which I have filed on 28th of April 2023, Lordship. Page number 6, Lordship.
6 of
in WPC 58 of 2017, I have filed my affidavit on 28th of April 2023, wherein I have annexed my permit, site permit, annexure 1, page number 6, Lordship. Yeah, annexure is not good. The site permit is also impugned. Page number 6, Lordship, in my affidavit. Page number 6, annexure 1.
Yes.
Site permit name Monyan Union. Lordship, if I may be allowed to read, Lordship.
Yes.
Wide reference government approved letter dated permit number.
You are reading which one?
Annexure 6, Lordship.
Annexure 6.
Lordship, the permit. Copy of the permit, site permit, Lordship.
Government of Nagar Office.
Lordship.
Site permit. Yes. What else is there to be read?
Here, continue with page number 7. It says, wide reference government approved letter number dated permit number TZ 110611 dated 15/5/11. Name Monyan Union. Village TZ town. Police station is TZ district Mon. He is hereby allotted a plot of land in Dizit area for residential / trade business purpose, measuring 80 into 80 feet. So the length is 80 and breadth is 80, Lordship. Now, here the location is north Wangshom site, east is Yanye site, south is Wangtom site, and west is Pathway site, Lordship. So through this site permit, respondent number 6 was allotted in the year 2011, Lordship. Now, since 2011, the said portion of the land was in possession of the Union Lordship, with the Union Lordship, since 2011, 15/5/2011. Now, somewhere, as also mentioned by the petitioner as well, somewhere in 2015, the Union come to know that the said portion of land allotted to them was sold to one Mr. Hong Long, and subsequently allotted to one Mr. Wong Tom Konyak by the petitioner Lordship.
Allotted to?
One Mr. Hong Long, initially, the land which is in possession with the Union has been come to know that it has been allotted to one Mr. Hong Long, and subsequently again allotted to one Mr. Wong Tom Konyak by the petitioner Lordship. That was in the year 2015.
No, it was first allotted to?
Allotted to the Mongyu Union Lordship in 2011.
Mr. Hong Long is, where is the, you have the annexed?
No, Lordship, I don't have.
Okay.
Lordship, I don't have.
The Union heard.
Yeah, Union come to know, Lordship, that the land allotted to the Union was sold to one Mr. Hong Long and subsequently again allotted to one Mr. Wong Ton Konyak by the petitioner Lordship. That was in the year 2015, Lordship. And therefore, a complaint was put forth in DP's court on 23/3/2017.
23rd.
Yes, Lordship.
Lodge complaint.
Yes.
Before whom?
Before the DP's court, Lordship.
Okay. You
DP's
have
court.
annexed the complaint letter?
Lordship, no, I don't have the letter, Lordship, but it has been communicated, Lordship. And so in response to that complaint, a summoned letter was issued, which is already imputed and annexed in the petition itself, Lordship. In response to the complaint put forth by the respondent number 6 on 23/3/2017, a hearing was called by the Debashu Court on 13/4/2017, Lordship, which is already annexed in the petition as annexed.
So someone is annexes?
Lordship, summoned letter is in page number 39 of the petition, Lordship. Page number 39.
Okay.
In the petition. If I may be allowed to read, Lordship.
Petition.
In the petition 58 of 2017.
Yes, 39, page 39.
Page 39, Lordship. Page 39. So in response to the complaint filed by the Union, this was a summoned letter issued by the Debashu Court. In the court of the DB's Office of the Additional Deputy Commissioner, Digit Nagaland, dated Digit 10th April 2017, summoned. A complaint letter has been received from Sri Zanai, President, and K. Apan, General Secretary, on behalf of Mongyun Union Digit Town on 23rd March 2017 against Mr. Wongton Konyak and Newton Konyak, Mr. Wongton Konyak of Newton Village for construction of building at Industry Ward, Digit Town. The said plot of land was already issued and allotted to Mongyun Union Digit Town, white permit number Digit 1106, dated 15/5/2011. In this connection, all concerned are hereby directed to appear before the DB's court on 13th April 2014 at 11 a.m. along with site permits without fail, thus but issued by the head DB Lordship on receipt of the complaint. So accordingly, the parties have appeared on the set date and the order is annexed in the petition itself, Lordship. Page number 40, the next page. Now, if I may be allowed to read this order, Lordship. Page number 40 of the petition. With reference to a complaint, letter dated 23/3/17, received from Mongyun Union Digit Town against Mr. Wongton Konyak of Newtong Village for construction of house at the allotted site of Mongyun Union Digit Town. In this connection, the DB's court, the ZIT, summoned both party to appear before the DB's court along with site permits on 13th April 2017. Now the Monyon Union District Town produced a site permit, so and so, whereas Mr. Wongton Konyak could not produce the site permit. Therefore, the DB's court, the ZIT, to hereby directed to Mr. Wongton Konyak of Newton Village to vacate the house and remove the materials from the said site on or before 13th May 2017. This is within 1 month from the date of this issue. Lordship, by this order dated 13th April, the ownership still, the land still belongs to the Lordship, the Monyon Union Lordship, the respondent number 6. The union has proved with a permit as has been directed by the DB's court and accordingly produced with a site permit which was issued by the government. Now, Lordship, since the land ownership belongs to the union, some developmental activities were carried out, Lordship, after this order, since the land was permitted for development. And so the union was constructing a community hall, Lordship. So some development activities were carried out. However, the petitioner again filed contempt petition 23 of 2022 and met the union as respondent number 2. Hence, all ongoing works were freezed since this Honorable High Court has stayed, given the stay order, Lordship. So accordingly, all the works has been stopped, and I have filed my reply as well, annexing that all the works has been stopped, Lordship. Now, Lordship, as per the record, the government initiated cancellation of permits in 2014, wherein they cancelled 111 permits. And by order dated 25 to 2020, also 12 permits covering an area of 4.43 acres were cancelled by the government also in the year 2012. Still then, the land measuring an area 80 into 80, which was allotted to the respondent number 6, still stands in the position of the Monyon Union till date as per the record, Lordship. The extension has been granted by the government since the site was permitted by the government, Lordship. Until date, the latest extension period is 31st of December 2024, Lordship, since it keep on extending, Lordship. Now, considering all these facts and circumstances, Lordship, the land was donated by Japoka, which has been annexed by the petitioner in page number 29 also, Lordship. As we go through the inquiry report, it is clearly mentioned that the land was donated by the Japoka village, Lordship. However, in nowhere, the landowners were met party as well, Lordship.
But if the land is decided in between the government,
Lordship,
and the petitioner,
Lordship,
then it will be governed, your case will be governed by this decision of the
Lordship.
Automatically, if it is for the government, then you get the land. If it is for the petitioner,
Lordship,
then it goes.
Lordship.
So,
but since I have been implemented as respondent,
okay,
I ought to have my put up my submission as well.
Yes,
Lordship.
yes.
So what I'm trying to convey to this honorable court is that ample of steps were also taken as were directed by the honorable court also in the previous writ petition. But since I'm not met party in the other 2-3 petitions, I'm not well aware of how and what the annexures are talking about. But as far as the annexures that has been annexed imputed in the petition, my attention caught into this inquiry report that the land was donated by Japoka village for development. And accordingly, the government has also allotted this 80 by 80 to the Monyon Union for development. Accordingly, the respondent number 6 carried out the work in constructing a community building, Lordship, for the welfare of the people, Lordship, residing in that particular town, Lordship. which the union is comprising of more than 18 villages, Lordship. Now, as per the permit was given to the late father again, wherein the petitioner has annexed in the petition as well that a land permit showing the evidence of the land permit order. Now, as we go through the permit also, it says that the land was given to the late father. However, there is no letter executed for transfer of the said land to the petitioner, Lordship. As far as the petition,
there is no
land, the execution of transferring the land, because they have imputed in the petition that the land was given to the father, late father of the petitioner. Petition page number 17 of the petition, Lordship. Special permit for farmland which has been deliberated. Special permit.
So you said that there is no delivery of land.
Lord, there is no execution.
Okay.
Because the land permit was given in the name of the petitioner's father.
There is no execution of
transferring the said land to the petitioner, Lordship.
to the father of the petitioner.
To the petitioner, Lordship. The land was
Okay, by father.
Whichever, either ways, either the father or either from the government as well, Lordship. There's not even a single document annexed or imbued in this 58 of 2017, wherein the petitioner was allotted or execution of any transfer of the said land was executed, Lordship. Because the initial permit says it is permitted to the father, late Wangshu Konyak, Lordship. However, I do not find any substantial amount of evidence to prove that the land was executed in the name of the petitioner, Lordship. Now, as I've mentioned, my submission is very limited because I've been given only 80 by 80 only, and that is for the development. And ample of cancellation carried on, wherein my permit still stands and the ownership belongs
cancellation of how many? You say 100 and
111 permits by order dated 25 to 2020.
By which order?
25 to 2020, Lordship. Which is in the inquiry report in page number 29, Lordship.
29
of petition, Lordship. The special inquiry report starts from 26, but particularly page number 29, Vara 3. The first line, it says, if I may be allowed to read, Lordship.
Yes.
There are already 111 notes of permits issued by district administration from 1998 till date. Further, 12 notes of plots were settled through the complainant and 17 notes without any permission. Adding up to 140 families already settled in that area. Trying to relocate these 140 odd families will create a lot of social tension, leading to a grievous law and order problem in the town. So this was the finding of the inquiry, special inquiry. So 111 plus 12, Lordship. So cancellation of permit was carried forth by the government in the presence of the petitioner's, Lordship. However, my permit measuring an area of 80 into 80 still stands, Lordship. And as I mentioned, my permit still stands till 31st of 2024, Lordship, which means I still have the ownership, Lordship, which is permitted by the government. Now, if I may bring to the notice of this Honorable Court, Lordship, that as far as disputed land is concerned, Lordship, that 157.81 acres, it is not an ancestral land, Lordship. So it cannot just pass down as per the customary laws which we practice in the state of Nagaland, Lordship. The instant matter involves a highly disputed question of facts as far as the land site permit measuring an area of 80 into 80 is concerned, Lordship. I have the petitioner which have implemented me as respondent number 6, who claims that 80 into 80 still comes under his land, whereas I have already obtained my site permit, Lordship, from the government, Lordship, who still claims that the land belongs to the government. And I have a well-documented and evidence to prove that I have obtained the site from government, Lordship. So, Lordship, the instant matter, as I've mentioned, is a disputed question of facts involves, which can only be adjudicated by the competent civil court, Lordship. If I may take you, Lordship, if I may be allowed to place my citation, Lordship.
Yes.
Lordship, if I may be allowed to read 1999 7 SCC.
Yes.
298, Lordship. Particularly paragraph 6 and 7, Lordship. If I may read.
Yes.
In our opinion, the High Court committed an error in entertaining the writ petitions, even though they were not fit cases for exercising power under Article 226 of the Constitution. The High Court went wrong in proceeding on the basis that as the deaths have been taken place because of electrocution as a result of the deceased coming into contact with snapped live wires of the electric transmission lines of the appellant, that admitted prima facie amounted to negligence on the part of the appellant, the High Court failed to appreciate that all these cases where actions in tort and negligence was required to be established firstly by the claimants. The mere fact that the wire of the electric transmission line belonging to appellant 1 had snapped and the deceased had come in contact with it and had died was not by itself sufficient for awarding compensation. It also required to be examined whether the wire has snapped as a result of any negligence of the appellant and under which circumstances the deceased had come in contact with the wire. In view of the specific defense raised by the appellants, in each of these cases, they deserved an opportunity to prove that proper care and precautions were taken in maintaining the transmission lines, and yet the wires are snapped because of circumstances beyond their control and unauthorized intervention of parties, or that the deceased has not died in the manner stated by the petitioners. These questions could not have been decided properly on the basis of affidavits only. Now, it is the settled legal position, Lordship, that where disputed question of facts are involved, a petition under Article 226 of the Constitution is not a proper remedy, Lordship. The High Court has not and could not have held that the disputes in these cases were raised for the sake of raising them and that there was no substance therein. The High Court should have directed the writ petitioners to approach the civil court as it was done in OGC number 5229 of 1995, Lordship. Lordship, I may be allowed to place on record another judgment, Lordship.
But here in this case, it is not the case that he was under the possession or not. It is the case probably that he was allotted by the government.
Lordship.
Or was allotted or is entitled or not.
Lordship.
Not the fact that it was under, he is not claiming that I was under possession and he was under possession, but it is question involved is here in this case is that whether the government, permission given to the petitioner by the government is entitled by
Lordship, but still in other way around also, even permit or even in possession also, now the petitioner is claiming that the entire plot of
No,
land belongs to him,
possession,
lordship.
possession, whether he was under possession or not, but
Lordship,
if the permit is valid, if the permit is valid, then he has a case.
Lordship, lordship. But here again, when in other petitioners also is that the land was donated by the by one village, particularly
That is not
Japoka
disputed. That
village,
is not
lordship.
disputed.
Lordship,
It was initially disputed, the land was donated by the villagers to the government, but then after being donated,
the lordship, but again,
then the
when-
government, after taking into possession,
lordship,
government allotted it to you also, to him also.
not allowed, lordship.
So, like the allotment given to the any other person, to the private like you also. So the
Lordship.
government has allotted him, permitted him.
Lordship.
So the question is that this permission is on the basis of the permission, whether the petitioner is entitled or not.
Lordship, lordship. But here in this, if I may be allowed to read through again.
Yes.
In one of the judgment again.
Okay.
2006 9 SCC 524. If I may be allowed to read. A high court is not deprived of its jurisdiction to entertain a petition merely because in considering the petitioner's right to relief question of fact may fall to be determined as pointed out in so-and-so case. In a petition under Article 226, the High Court has jurisdiction to try issues of law and fact, where, however, the petition raises complex question of the fact, the court should not entertain the petition. The High Court refused to go into the question as to whether trusts were public or private trusts, as the question has involved investigation of complicated facts and recording of evidence, lordship. The view was upheld. Thus, if there is a question on which there is a serious dispute which cannot be satisfactorily decided without taking evidence, it should be decided in a writ proceedings. If disputed question of facts arise and the High Court is of the view that those may not be appropriately tried in a writ petition, the High Court has jurisdiction to refuse to try those questions and relegate the party to his normal remedy to obtain redress in a suit. Now, in a petition, Article 226, the High Court has jurisdiction to try issues both on fact and law when the petition raises complex question of fact, which may, for their determination, require oral evidence to be taken, and on that account, the High Court is of the view that the disputed statement may not be appropriately tried in a writ petition. The High Court should ordinarily decline to the petition. Thus, a High Court is not deprived of its jurisdiction to entertain a petition under Article 226 merely because, in considering the petitioner's right, question of fact may fall to be determined. Ultimately, the question is one of discretion which is to be exercised in conformity with judicial principles, lordship.
So, what according to you,
lordship,
in the instant case, the fact of the the question of fact involves
lordship,
several, according to you,
lordship, lordship. Now, lordship, if I may allow to place
whether the question of fact involved here,
lordship, lordship.
What is that?
Lordship, now the petitioner claiming 157.81 acre.
Admittedly, you see, Chief Secretary also admitted.
Lordship.
Chief Secretary clearly says that the commitment given by the earlier authorities should be what you call
it's a final.
Yes.
Final order, lordship.
Yes.
Assuming but not admitting, lordship. I'm just going through by the impugned.
Right.
Impugned only. So I'm assuming but not admitting, lordship.
Yes.
Other way around, the government also have proving themselves that the government land belongs to them. Subsequently, I have also obtained my site permit from the government only, lordship.
No, that is true. Subsequently,
lordship,
lordship.
So
no, just because you have raised this question of law and fact.
Lordship.
I just wanted to know if there is really involvement of the question of fact to be decided here.
Definitely, lordship.
Fact like what?
That there are, lordship. The allotment order.
No, allotment order here.
Of the land, lordship. But that is a disputed, lordship. That's still disputing by the government, lordship.
No, the permit, it is not disputed.
No, lordship.
How it is disputed? Just tell me.
Lordship,
because you see, the permit, if it is disputed, then there would have not been any cancellation order.
Lordship.
It's a subsequent cancellation because there was a
lordship.
Undisputedly it was allotted, permitted. That is why cancelled. So this allotment or the permission given to the petitioner has been admitted by the Chief Secretary.
Lordship. Lordship, however, lordship,
the fact probably is not involved.
If the land was in possession and the full ownership was with
of course, if the question comes that he was under possession, not possession, that comes under, of course, fact.
Lordship. Now that if, suppose, assuming also, Lord, if the land was in total possession of the ownership belongs to the petitioner only, I could have obtained my permit from the petitioner. But my site permit was from the.
It was
government.
only, probably, it was only because the entire land was not absolute possession of, not under the absolute possession, physical possession of the petitioner. That is why the government involved and allotted also, it
Lordship,
appears.
but as far as respondent number 6 is concerned, the land measuring an area of 80 to 80, the petitioner claiming that this land comes under the jurisdiction of the petitioner.
According to you, it doesn't come under.
No, that is their claim, Lord. And
Yes, and according to
that comes under 157.81 acres, Lordship, which is a disputed land.
So
as of now,
your land allotted to you comes under the land permitted
to the
yes,
petitioner, Lordship.
then no dispute.
No, but
yours is claimed only on the basis of the allotment given to you by the ADC.
Lordship.
So that the question that is not a fact.
No, but Lordship.
Question of law. When the land was already permitted to the petitioner, whether ADC could have allotted land to you or not. Law. Question of law. Probably. Not a fact.
Lordship, but there is no execution in to place on
that
record.
Of course, that is question of law.
Lordship.
That is question of law. Whether in absence of the execution of the transfer of the property, whether the petitioner is entitled to claim.
Lordship. I still stand.
Claim the land of his father belongs to him.
Lordship.
So that of course is a question of law again.
And today, suppose if I admit, like tomorrow again, the petitioner will say, no, 80 by 80 comes under my land, so your permit does not stand, Lordship. And that is the reason why I'm making my submission that this is a disputed question of facts, Lordship. I have two owners now. One is the petitioner and the other one is the government, wherein I got my
fact will come between you and you, not with the government. That you were not under possession or possession, etc. That, of course, the law fact will come. But then probably here in this case, the question of fact may not come.
I would still stand on the disputed question of fact. Lordship, I may be allowed to place
please.
Judgment, Lordship. Please pass by this honorable court, Lordship.
So the relevant.
Lordship, this is WBC 357 of 2021, Lordship. Passed by this honorable court, dated 4/4/2023, Lordship.
Yes.
Lordship. I'll just read this facts of this case, the gist of this case in page number 2, Lordship.
Yes.
Paragraph 3, clause 2, Lordship. Clause 2.
Yes.
That by order dated 17/12/1947, issued by CRPC, the 10th Deputy Commissioner, Nagaland, Naga Hills, Shri Jai Kisar Kachari was allotted to cultivate 10 acres of land. To cultivate 10 acres of land in Tak so-and-so, under Dimapur Moza, Lordship. On the death of Jai Kisar Kachari, the land belonging to the deceased was inherited by his son Arun Kachari, who was issued with Pata number 6, Tak number 31 and Tak number 21 in block number 8 of Dimapur Town on 1st of August 1969. Dak number so-and-so land. While Dak number 21 carried so-and-so of land, the present dispute pertains to the land in Dak number 31. So this was also a land allowed to cultivate 10 acres of land, permitted. But subsequently, the son inherited by way of execution of Pata, Lordship. That is how he owned the land. Now, if I may allowed to take you to, Lordship, to paragraph 15, Lordship. Paragraph 15, Lordship. Page number 10. Lordship, if I may allow to read, Lordship. Paragraph 15, Lordship. So considering this facts and circumstances, so also in the case of Union of India and another versus State of Assam and others, reported in 2014 for NJE 30 Gauhati, the Honorable Division Bench of this court held that 1. In our considerate opinion, the writ court single judge should not have embarked upon any factual inquiry, much less roving factual inquiry into the question of ownership of the land and writ jurisdiction under Article 26 and 227 of the Constitution of India, and nor it had jurisdiction to do so. In no case the writ court have returned the aforesaid finding of fact and declared the respondent number 6 to be the owner of the land in question in this proceedings. It is a settled law that the Revenue Court, while deciding the rival claims of the parties in mutation proceedings, does not possess the jurisdiction to decide the ownership claims of any party on a particular land. The jurisdiction to decide the ownership issue in relation to immovable property is with the civil court. The mutation proceedings are subject to the result of the decision of the civil court, and depending upon the civil court's decision, the order of mutation is passed in favor of the party in whose favor the decision is given by the civil court. Now, 14. In substance, therefore, the Revenue Court not decide the rival ownership claims of the parties over the land and had to grant liberty to the parties concerned to get their claims adjudicated by the civil court in a civil suit. 40. The writ court, while deciding the writ petition arising out of such mutation.
That is true.
Lordship.
The dispute between the parties has to be decided by the civil court only.
Lordship.
That is true.
Lordship.
But then here is different.
Still, I would make my submission that there is
how it is dispute between the government and the private.
Now, the petitioner cannot go.
Now, if it is a dispute between you and the petitioner, is of course
Lordship.
Question of fact.
Lordship.
So whether it comes under his land or yours is independent.
Lordship.
So that is a dispute of fact.
Lordship.
But then with the government, so how this question, the question raised by the petitioner?
It is a disputed question of facts because even the landowners have also made a complaint in other petition, Lordship.
If the landowner says that we did not give,
Lordship.
or so landowner say that this is not this does not come under the land donated by us, then it's of course dispute
Lordship,
of
but
fact.
they're not part. They were not made party in this.
No.
There is a complaint.
Whether are they saying that the land was not donated to the government?
Yes, Lordship. Yes,
No.
Lordship.
Where?
They have made a complaint.
Then it is a dispute of fact, of
Lordship,
course.
Lordship.
Then it is a dispute. It will be a dispute of fact.
But considering overall, Lordship.
No.
Considering the facts and circumstances, I would still make my submission and admit that, Lordship, this is a question of fact, Lordship.
Now, let us see the question of fact. What is the question of fact?
That the land ownership is still disputed, Lordship.
No. Land ownership, how it is disputed? The government still says that allotted. Government still says that he was permitted.
It was a permit, Lordship. That's what the government submitted, Lordship, for cultivation, Lordship. And this is exactly the matter suit herein and decided by this honorable court also that.
Permission given to the petitioner is not disputed.
But where is then how can the petitioner prove beyond reasonable doubt that there is an execution and the land belongs to the petitioner?
That may of course come under the question of law.
Lordship.
That it was not properly executed. And then the petitioner, it is in the name of the father, not in the name of the petitioner.
Lordship.
And the petitioner did not have any land possession certificate of his own. And the petitioner did not succeed it properly.
Lordship.
There is no succession certificate that giving this land in the name of the petitioner. So all those, if that raised, that is a question of fact, of course.
In the permit itself, that the cultivation, all the land will be surrendered back, give back. That's what the permit says, Lordship.
No, where?
Lordship.
Show me, please.
Special permit in farmland at Dizit, Lordship, page number 17. It's not very clear. In 58 of 2017, page number 17. This is the basis of this matter, special permit for farmland at Dizit.
Page 17.
Page 17, Lordship. If I may be allowed to read, Lordship.
Please.
I'll read through. It's a short one, so I'll read through the entire.
Is there any clear type copy? No.
Lordship.
Okay.
In 88,
if it is
it's
legible.
Clear, in petition 88, it's clear, but in 58, it's not clear, Lordship.
Okay.
In petition 88, page number 32 is clear. It's a type copy.
Just a minute. 88 page.
88, page number 32, type copy, Lordship.
Yes.
Lordship, if I may be allowed to read.
Yes, please.
Government of Nagaland, Office of the
Okay,
Additional
start with the content. Okay.
Lordship.
Special
Yeah.
permit.
Lordship, special permit for farmland at Digit, dated 29 March 1971. Shri El Wangshu Konyak, RCM, is allowed to continue cultivation of the low-lying areas, which he has already put under petty cultivation at Digit. The line of demarcation with follows as follows. A straight will be drawn from a point on Sonari Mon Road as shown in the survey map till it join another survey marked near the private track as shown in the survey map. From the survey map point, it will run straight south till the line reaches the first line of banana trees, after which it will turn straight northwest till it comes parallel to the point marked on the stem by me on 24/5/1971. Taking the last point of northwest line, a straight line should be drawn, the word south crossing the marked stem till it reaches another marked on the dead tree. From this dead tree, a line will continue straight for a few yards, then turn southeast and join the now Jum area. Following the area already Jum this year, a line should join Digit River near the pool called Chezak. Besides this area, he is also allowed to continue paddy cultivation at the confluence of Digit and being shown in the map as besides these two areas, he should vacate all areas he has put under cultivation immediately, Lordship. The ESC Mon who was with me is requested to go down and put boundary pillars with the help of Sri so-and-so and his laborers, Lordship. So the last line, Lordship, besides these two areas, he should vacate.
Yes.
Lordship.
If he hasn't vacate,
Lordship,
as per the last line, and if he is still under possession, beside that too,
Lordship,
about the beside this two, if he hasn't vacate,
Lordship.
So then, of course, and if you are claiming that is under the lane,
Lordship,
these land are still under the possession of the petitioner is claiming this land, which he was asked to vacate.
Lordship.
Then, of course, that is question of fact.
Lordship.
But then, what is your claim here? Whether he hasn't he vacate the rest of the
Lordship,
cultivation?
At this point of at this juncture, I'm not
it appears that thereafter he was under the possession of those land only and has vacated the rest.
Lordship.
It appears.
Lordship, it appears to be, Lordship. It appears to be. Lordship, but still then, I will still stick to my submission that it is a disputed question of facts.
Just a minute,
Lordship.
minute. Let us see. I'll just show you one line that the authority, the district administration earlier decided should be honored. Where is the chief secretary's letter? Can you just?
Since you are in the page 8,
80. 18 of?
58, page 18, annexure C of 58, Lordship.
Yes. See, read the last paragraph. No? Please read the last paragraph. While saying all those, okay, for that purpose, let us be clear. Let us read from the very beginning.
Lordship.
Yes.
Page number 18, annexure C, Lordship. A representation has been submitted to me by L. Nogmant Wangshu, son of late Logdan Wangshu, alleging that illegal encroachments have taken place in the land given to his father, which he has inherited. This special permit for farm land at the Zit was given to late Logdan Wangshu, the 10 RCM, and the area given to him was properly delineated. In course of time, encroachments have been placed by police department, industry, department and also by private individuals through permits given by administration at different times. The land given to late Lokten Wangshu, the 10 RCM, was in recognition for the assistance he has rendered to the administration and also for standing for the people in times of difficulty. In fact, without his consent or his successor, no land should have been allotted to any person or government departments. It appears that no respect was shown to permit holder who was given the farm land by administration in recognition of his services given to the government and the people. Even the Angs of Dizit area has consented to this as the land falls within their jurisdiction. The administration should always honor the commitment given by previous administration to keep its image in the eye of the people.
See, so here here not only admitted, confirm also, reaffirmed
Lordship.
the Chief Secretary.
However, subsequently, ample of inquiry was also took place wherein the petitioner also have admitted that to settle the matter.
Inquiry was created by somebody else.
Lordship.
So he has written this letter on behalf of the government only.
Lordship.
So that is after that created, and then of course, Mr. Angami also raised that the petitioner himself has made request to come into understanding out of court. There, of course, a different.
Lordship. But the last, this is the observation. If the administration allows encroachment by individuals or government departments, it does not show any good image before the public. Now, you are hereby asked to conduct special inquiry and submit detailed report, comments.
There is especially about the encroachment and who else are doing encroachment in order to protect the lane of the petitioner. It appears here.
But Lordship, I assume, and placing on record by the councils also that there were ample of inquiries and consultation has been held, Lordship. However, Lordship, as I come to the end of my submission, Lordship, I would still submit that the land is in position now 80 by 80 as far as I'm not talking about
that is also not, I think, that is also probably, you are also not disputing that he is under, the union is under possession.
They forced their way into the land and they have started some.
Yes, that is not disputed. That is not disputed.
It is not a
If it's not disputed, Lordship, then that ownership belongs
to
you.
You are entitled only. You are entitled only if the land goes to government.
If the petitioner says so, like we are entitled by 80 by 80, then how comes we are in this honorable court?
If this petition goes, you are entitled only.
Lordship.
Because that is not disputed.
Lordship.
Anyway.
Even if the petition goes and still the 80 by 80 stands to me, Lord, I have no objection, Lordship.
Okay.
Otherwise,
so,
Lordship,
what we'll do,
I will submit
what
that
we'll do here in this case,
Lordship.
Because probably all the parties need to submit the written submission here. It will be difficult because so many things have come up.
I'll try to make it as brief as possible.
Yes. So because so many things.
In all the three cases.
And then so many petitions also filed.
Yes, in all the three cases, I'll summarize the separate.
So we'll keep it for submission because I'll be here for entire month. So I'll be there. So we'll keep it for one day for submission of written argument. Thereafter, because I have CAB also, another CAB which I need to complete during this period.
Yes, Your Lordship.
So
Your Lordship may fix a date for convenience.
When do we fix?
You want to do it earlier also, you can do it. What about here? Somewhere in between that? 2 weeks, no? 2 weeks, within 2 weeks. Oh no, before 14 or 15, if Your Lordship may.
Okay. So we'll fix on 14 or 15, no?
Yes.
Okay.
15 is, oh yes. Then it will, 16, Your Lordship, 16
okay.
will do, yes, 16.
Okay.
Mr. Tongpok Pongna, non-counsel for the petitioner. Also had Mr. Anangami, Learned Government Advocate for the state respondent, and Ms. Apila Sankti, Learned Counsel for the respondent number 6. In WPC number 58, huh? So this is in 6 in WPC. Hmm. List, is agreed upon by the parties. List this matter again on 16.
16.
Your Lordship. And
There's a part hard for,
the parties the parties will submit a.
on which day
written-
the
written,
parties will
yes.
submit
Written
their respective written argument.
Yes.
Okay. So this is